Okay, so welcome everybody to the January meeting of the PRC. So thank you for attending. I can tell you that we have regrets from Kyle, from Andrea. Peter indicated that he'll probably attend, but he'll be late. Brendan, did Peter talk to you about minutes?
He did not, no.
He didn't. Okay, that's okay. He's going to watch the video afterwards.
Okay.
So I thought he might have indicated that. That's fine. And Matthew has picked up a sessional course. I think it's at Laurier, which he actually teaches at this time. And so I don't expect Matthew to return to us until the semester is over. All right, so that's it for
That
regrets.
damn teaching always gets in the way, Miles.
It does. It does. All right, guys. Okay, so I sent out the agenda, I believe, on Saturday. So hopefully everybody's had a chance to take a look at it. So can I have a motion to approve the agenda? John, thank you. A seconder? Irving, all those in favor? Thank you. Okay, we're just going to admit Lynn now. There we go. Okay, and likewise, the minutes of the meeting, very adeptly prepared by Brendan for last month, have been sent out. Can I then have a motion to approve the minutes as circulated? All right, John again, seconder.
I don't know if I'm allowed to second my own minutes.
Okay, so that's fine. All those
Go for it.
carried. Thank you very much. All right, guys, let's move on to news. So the first item deals with Peter with respect to the ongoing issue of Alberta creating its own police service. So he's going to be sending us something or delivering something for us. If it's not today, I'm sure it'll be at the next meeting. The next issue item is the item that I pulled from the news. Obviously, it was very prominent in the last month or so, dealing with the killing just after Christmas of OPP officer Greg Pirshella. It generated a lot of news. I thought it was important for the PRC to look at this. In that, if we wanted to, we could, put a position paper together pretty quickly. But we should discuss it firstly because clearly the issue in that case was as tragic as the death was, the perpetrator, the gentleman who killed him, was out on bail, and if I'm not mistaken, there was a warrant for his arrest that had been outstanding since I think June. He had quite a history of violent crimes with firearms, and he had a lifetime ban for possessing firearms, which obviously he didn't care about. Any thoughts on this particular piece by anybody? I have some thoughts, but I'd like to hear what everybody else says. Lynn?
No, I'll wait and go last. Thank you.
Okay.
He was also has a record of assaulting police officers as well. It's funny, I was talking to a police friend of mine, police officer friend here in Toronto, and he was saying the policy of at least the Toronto Police Service, and I think it's the same in Durham, because I know this case, this guy was on bail and he had no fixed address. So they're doing less show causes and they're releasing people, whereas in the past, more readily than in the past. And I'm just wondering whether it's because there's too many people in custody, the administration is bogged down. This one case in Durham, this guy had no fixed address. Actually, when I was in probation or parole, I was his officer, and he has a history of violence and drug use, and he never showed up for his court case. And actually, I was trying to follow up whether the coppers, because I know where he is, whether the coppers would arrest him. And they said, well, unless he commits further offenses, no, he's out on an undertaking that the coppers released him on. So it's really horrendous in terms of what's going on in bail, because the prisons are filled, the remand or the coppers are too busy. They won't bother unless you're a big fish. So, but the public is at risk. It's a real problem.
Brendan, you had your thanks, Stephen. Brendan?
Yeah, I actually have two comments. One is a little more, it sort of comes off what Stefan was saying there. It's part of my doctoral research right now. I'm actually looking at like the use of like bail and and incarceration as a sentence, like during COVID. And I think, yeah, right now it seems like we're still trying to avoid because we're still trying to avoid putting people in the prisons right now, whether it be for bail or sentencing. And I, the issue is like that's more of a general trend that I've been seeing. And I think most would agree with that's kind of how it's been throughout the pandemic. But I think part of the issue is, and maybe this is just me, but I don't think we have a lot of information on this case. There's a lot of missing information, and I think that has been causing a lot of issues too, because we have these stories coming out in the newspaper, and it's not just this case specifically. It's in a lot of like these really salacious sort of cases that come out in the media, and because my understanding is that there's a publication ban on this case, and so we don't have all the information. And I just want to make the link with like this case moving on to with publication bans that like I I don't know what others think, but I think that publication bans are almost used a little too liberally, and like, we're hiding information that could be really useful. So it creates this like shroud of secrecy around cases, and it makes things worse than they need to be. So I know that comment sort of splits from the case in and of itself, but I think it's just very symptomatic of the overuse of publication bans, if indeed a publication ban was used in this case. I don't know if that's something that we've ever discussed, or sorry, the PRC has ever discussed generally, but that's just some of my thoughts.
Thanks, Brendan. Howard?
Just, I mean, there are a lot of things to be said about this. So but for now, I'm just want to limit myself to just responding to something Brendan said. Often the evidence at a bail hearing is subject to a publication ban. And the reason for that is that at a bail hearing, there's all sorts of evidence. I even put it in quotes, evidence. There's all sorts of submissions that would never be allowed at the trial. It's hearsay. A lot of it is unreliable. The focus is often on things that are relevant to the trial, but potentially prejudicial to the accused. And so while I agree with you absolutely, Brendan, and there have been some challenges to the automatic publication bans under the criminal code, there's some automatic ones and then there's some discretionary ones, but even the discretionary ones are imposed as a route. And as you all know, if you're watching the media, in the context of sexual assault, there are a lot of victims, alleged victims, so-called survivors who want to be named so they can tell their stories. They're having trouble actually getting publication bans lifted so that they can tell their story. But in the bail context, the specific reason is that it's a pretrial kind of hearing where it's wild and loose, and everyone's, this is material that should not be made public and should not influence the trier of fact before it goes. And so that's the reason there. But you're absolutely right. There's a lot we don't know. This fellow was held in custody and then released on a bail review. And part of that may have been his indigeneity, but I think one of and only one, this is a very complicated problem. And the article that Miles sent linked in the agenda is really good because it cites a whole bunch of people, a lot of politicians saying things they should never be saying publicly, damning a system without knowing it. But it's also got Jane Sprott, Tony Dubin, other good people. The debate seems to center to some extent on Bill C-75 because Polyev has cited it. C-75 made some changes. We've talked about this in the PRC, but that's a whole nother issue. I don't think the fault can be laid at the feet of Bill C-75. It's almost a bit of a red herring, but it's a complicated issue. But one of the things I wanted to just pick up quickly is what Brendan had said is whatever is happening on the bail decision, and remember across Canada, over 70% of the people in provincial custody are awaiting their trial. In Ontario, the percentage is higher than 70%. So the vast majority of people in provincial jails have never been convicted of an offense. But the police do not seem to be enforcing the breaches of the conditions. It seems to be a regular matter that people who are released on bail but breach their conditions and should be brought back in one way or another, the police are simply not doing it. The police will say it's because they don't have enough resources, but if you look at the proposed increases in the police budget in Toronto and on Ottawa, it's staggering the amount of money they get, and the fact that they get without any real argument or evidence annual increases. Even when they call it, I'm going on at length. I'm going to stop in a minute, but in Ottawa they called it the last budget increase. Even though there was a percentage increase, the Ottawa Police Service called it a cut to their budget. So I don't know. There's a lot of things all tangled up in here. There's not the article Miles gave you is one of the better ones on this topic. In the newsletter, there's an editorial piece by Daniel Brown, who's the president of the Criminal Lawyers Association in Ontario, and it's good as well. It talks about principle. But remember, over 70% of the people in provincial jails are presumed innocent and are doing some of the hardest time. I was talking recently to a very excellent defense attorney here in Ottawa, and I said, you know, in many ways, pretrial custody is worse than sentence time. And he said, no, Howard, in every way, in every conceivable way, pretrial custody is worse than sentence time. So anyway, I'm going to stop there. But it's Miles. I'm glad you raised this. Lametti simply, in his comments, defended Bill C-75. Again, stuck to the red herring and didn't deal with the real issue. I'm glad he wasn't promising amendments, but Mark Mendocino, the public safety minister, has been. Of course, he's been beleaguered with this because some people see this purely as a public safety issue. But he's talking about a system-wide review, and some of the media coverage of things that he said are much more aggressive in terms of proposed changes. It doesn't sound like for the better, but anyway, it's something the PRC should be seized of. We talked about bail before in some of our various briefs and stuff, but it's a good topic. It's a critical topic, I think.
Thanks, Howard. Lynn, did you want to step in? No, you good? John, you?
No, I was just
Yes,
sort of agreeing, and there's no need to go on, but I could add to what Howard is saying in terms of the and I mean, just there's some cases that are going on here that also reflect what Brendan said about mental health situation, where because of the COVID and using that as the escape hatch, but the system is turning people who are presenting themselves willingly, holding them for the minimum time, and then sending them back out. So I think there's a lot whether we blame it on COVID, but it's an interesting phenomenon that I think we're seeing on many levels across the systems.
Thank you. All right, guys. What I would propose is we watch this, and if anything comes of it by way of legislative reform or movements in that direction, then I think we could certainly get involved. I have opinions like everybody else on this particular issue. And so I think it's certainly worthy of the PRC to keep on top of it. So let's keep it on the agenda, and we'll watch and see what happens, and take it up if that becomes something that we decide to do. Is that agreeable?
Yep.
Good. Thank you. Okay. Any other news items that we want to touch upon? I usually take these from Howard's weekly publication. Okay, let's go to business arising then. So first things
Miles?
first. Yes, Howard.
Sorry, Miles, just an advertising feature on our newsletter, which Olivia and I work hard on, and Irving helps us a lot on. There's some good things there from Sundays about upcoming agendas of the court. Case law from the Supreme Court in 2022. It's amazing how busy they were. They're worth a look. And also there's a piece in there about the bills that are facing Parliament in the winter session, all from very good sources. So if you get a chance, there's just some good stuff that helps us prime ourselves for what may be coming along in the new year. So anyway, so much for my advertising.
No, and it's good. It was an excellent read, Howard. So thank you. It was good to. I'd seen both of those in different contexts, but I mean, it was nice to see it consolidated in the newsletter. So it certainly was worth taking a look at. So thank you. Okay, let's deal with justice-related parliamentary committees. The first one, back to you, Howard, is the Commons, Justice, and Human Rights. Howard, you're
muted.
off. There we go.
Some people would think I should stay muted all the time, but anyway, what can you do? I'm happy to say this is a brief report. There have been no meetings of this committee since our last PRC meeting. The last meeting actually of this committee was December 12th, the day before our last meeting, and they looked at Bill S4, which actually has now received royal assent as of December the 15th. So it's kind of academic for purposes of the committee. The bill has passed and it is law. This is the bill that in its short title was called the COVID response, and it really was a series of sort of small level technical amendments, a lot having to do with the use of technology, and some of it focused on jury selection, but not a huge reform bill. But it is now law. And the other thing that they looked at was they've been studying, quote unquote, the subject matter of Bill C-28, which is the self-induced extreme intoxication bill, which also has already passed, but it passed on June the 23rd. So prior to the committee's study, the committee has issued a report, and it's Report 10, The Defense of Extreme Intoxication Akin to Automatism, a study of the legislative response to the SEC decision in Brown. And Brown was the decision where the court actually said that, I want to be careful with my words, but that intoxication akin to automatism is a defense and must continue to be. That in that case, there is no actus reus. There's no mens rea, but there's not even an actus reus. So anyway, theoretically, that was the right decision, and it prompted a response, and the government's response was this Bill C-28. Those were things that the committee was working on and had finalized just before our last meeting. And I bring them up only because, particularly in the case of the last matter, the report 10 was finished and was sent to the House on December the 13th, and a government response is requested. So S4 is academic. It's worth taking a look, but it is law now. The question, I guess, is to some extent how much it will change things, if at all. There are some useful changes in there. I don't mean to deprecate it. And C-28, the funny thing, and I have to apologize for this, it may be the fact that I left it too late, but all of the links to all of the reports produce a message on the Government of Canada, Parliament of Canada website that says, sorry, this page is no longer available. I cannot link today with any of those links, no matter how hard I try, and I tried different ways to do it. But so there's something wrong with the Parliament of Canada website. But what I will do is, when I can get a hold of that report on self-induced intoxication, I will send it to our capable chair, who can share it with all of you at his discretion. I'd like to see what they say about that. Some people see it as a conflict between legal theory of mens rea, actus reus, operating mind, and all of that. Others see it as a get out of jail free card for particularly men who get terribly drunk and sexually assault someone. As you know, alcohol intoxication is not a defense to a sexual assault. And there's the whole issue of general intent and specific intent. That's not what Brown was about. Brown was about a state where there is no operating mind. At any rate, I will follow up with the report on self-induced intoxication and make that available to Miles, who can share it with you all, but I'm going to just stop right there.
Thank you, Howard. Any questions or comments for Howard? Brendan?
I just have one really quick question or / comment. I had the same issue with you on the parliamentary side. I can't access any of the documents. With that said, I was just wondering, and this is one I've been trying to verify this because for Bill S4, it was one that it obviously originated in the Senate, and I know there was discussion of having a review about the use of like similar to some other bills, having a review in 3 or 5 years on the use of AV technology in courts. Do you know if that made that its way into the final bill, or like I said, I wasn't able to verify that, so I just was wondering if you recalled.
I believe it did, Brendan, but I'm just trying to pull up the Parliament, the Legisinfo website now.
It's not working.
It's so frustrating. I was on it for a short period of time. Let me just see. I've got S4 open up now, but let me see if I can get to the bill.
Yeah, I was able to get on Legisinfo, but when you look at like
Yeah.
text of the bill, yeah.
Same.
Okay.
Yeah, no, same thing. You can't get to the text of the bill. I believe that review was, I believe the review was left in. I think the committee also has talked about doing its own review of the use of technology in this context. Brendan, you're very well tuned into this, because although all of us think for the most part, the use of technology that will help speed the process is a good thing, there's the real question at the bar as to whether appearing virtually is the same quality of justice as appearing in person. And of course, judges have this whole thing about being able to automatically divine credibility if they can actually see the person in the same room. But there are also some real access to justice issues that you have raised, Brendan, both with the committee and in other contexts in our group, about not everyone having access. And we've been seeing how slow the internet service is in rural areas. So there's serious issues in all of that. But Brendan, I have to believe there's just some kind of glitch this week with the Parliament of Canada website. I think I think they have a constitutional obligation to get that website up and running. Don't mean to make too lightly of it, but you and I rely on it a great deal. It just was really frustrating that all of the links seem to be down. So anyway.
Okay. Thanks for that, Howard.
Thanks, Brendan. Thanks, Howard. Okay, the next committee is Public Safety and National Security. That's Rob. Thank you.
Good afternoon, folks. The committee has not met since our previous meeting on December 13th. So therefore, we have nothing to report.
Okay, thank you, Rob. Senate, Brendan, Legal and Constitutional Affairs.
There was there was two meetings since we last met, but it was actually the meetings were held on the day of our last meeting. It was on Bill S11. I was discussing this with Howard actually, and Bill S11, it's more of a technical bill. Nothing too interesting. It's just the harmonization of like common law versus civil law in Quebec, and that's about it. So I won't go any further than that.
Okay, thank you. Okay, with myself, as it turns out, and as everybody knows, the Senate Committee on Human Rights has been dealing with all things Islamophobia. The last report I gave at our PRC in December was that they had tabled the report. It was in camera, so I couldn't access it. But the day after our meeting on December the 14th, they actually tabled it in the open. And it deals with basically Canadian barriers to humanitarian aid in Afghanistan. So I'll give you excerpts from the report and the recommendations. So following the withdrawal of the United States and NATO forces from Afghanistan in 2021 and the corresponding return to power of the Taliban by force, the humanitarian situation in Afghanistan has become particularly dire. Millions of people in Afghanistan are in need of humanitarian assistance due to the combined effects of war, natural disasters, drought, COVID, and chronic poverty. Over 35 million Afghans have been displaced, with 80% of these being women and children. This has left them vulnerable to starvation and facing the winter without shelter, with over 1 million children at risk of starving to death. And here's the issue for the committee. Section 83.03 sub B of the Criminal Code makes it an indictable offense to provide property or financial services directly or indirectly, in quotes, knowing that in whole or part they will be used by or will benefit a terrorist group. The Taliban has been listed as a terrorist entity since 2013, and consequently Canadian organizations are currently unable to provide humanitarian assistance in Afghanistan without risking criminal prosecution if, for example, they pay taxes to the de facto government. Amy Avis, General Counsel of the Canadian Red Cross, highlighted the impact of this barrier, explaining that for the Canadian Red Cross, critical programming that includes the provision of midwives in remote areas is no longer being provided. She added that as the situation in Afghanistan becomes increasingly dire, shipments of aid remain paused and supplies sit aging in warehouses. Section 83.24 of the code provides that proceeding for terrorism offenses can only be commenced with the consent of the Attorney General. Witnesses discussed the possibility of using this discretion to provide an assurance of non-prosecution to organizations seeking to provide vital humanitarian aid in good faith. Kent Roach, professor he has the Wilson Chair at the Faculty of Law at the U of T, suggested that an assurance of non-prosecution in such cases could be done quickly, adding that non-prosecution agreements are common in the corporate context and that there is no particular reason why similar statements could not be made in the humanitarian and human rights context. So the first recommendation of this committee was that, in accordance with 83.24 of the Criminal Code, the AG of Canada immediately publish a guarantee that proceedings will not be commenced under Section 83.03 sub B in cases where legitimate aid and, absent any terrorist intent, results in an incidental benefit to a terrorist group. The government response to the special committee indicated that the government is considering legislative solutions to this issue, such as an amendment to Section 83. The next recommendation, that the Department of Justice urgently introduce legislation to create an explicit humanitarian exemption to Section 83 of the Code, clarifying that legitimate humanitarian aid, absent any terrorist intent that results in an incidental benefit to a terrorist group, would not fall within the ambit of the provision. And lastly, that the Government of Canada urgently increase its humanitarian assistance to Afghanistan and neighboring countries and continue to ensure that reasonable steps are taken to minimize the accrual benefits to the Taliban. All right, so did everybody understand that? So basically what is happening is that groups like the Canadian Red Cross have stopped providing aid to primarily women and children in Afghanistan because the avenue to which they provide that aid goes to a group that potentially pays taxes, income taxes to the Taliban, as a function of that is in contravention of the Canadian Criminal Code. So, clearly what the Senate committee is basically saying is that notwithstanding Kent Roach's very practical solution, basically the committee is saying, let's amend the code so that that is no longer an inhibition to providing humanitarian aid. So interesting. I found that a very interesting conundrum that aid organizations in Canada face, and hopefully some solution is made. Obviously expeditiously, because aid is not getting to those who really need it in Afghanistan and neighboring countries. Any comments or questions about that? Okay. All right. Thank you. That's my report for that particular committee. Okay, moving on to other business arising. So the items that still have matters that are outstanding is the item dealing with consultation on facial recognition guidance. And Peter and Lynn, we're going to prepare a draft review. Lynn, you're here. Peter's not. Is there anything happening on that?
There's nothing that, no, I must confess that over the holidays, I did not reach out to Peter. So that'll be one of my to-do items before the next meeting. Thank you.
No problem at all. Thank you very much. The other item outstanding on this issue, on this list, is Matthew and Kyle's report dealing with alternatives to incarceration. It's been on for quite a while. We've lost Matthew for a few months, and Kyle isn't here today, so we'll just simply let that stand on the agenda the way it is now. Proposal sub I, proposal for discussion, seek provincial support for including criminal records as a ground for discrimination in human rights codes. That's me. So what I've done since our last meeting, as I have attached to the agenda, is just a preliminary overview of the legislation, and then whether it's either a Human Rights Code or Human Rights Act in all the jurisdictions in Canada, which are the 10 provinces, the 3 territories, and the federal government. And I created a chart at the top of that to show everybody what the positions are in each of those jurisdictions. So the first category being a criminal conviction being protected as a prohibited ground. strictly on its own, as without any anything appended or supplementary to that, does not exist in any jurisdictions in Canada. So that's not a position that I don't think would be tenable putting forward for the purposes of trying to get everybody to agree to a certain position. The second position, which provides a limited protection if you have a conviction, if it relates to employment, that is available, and you can add Newfoundland to that list. So BC, PEI, Quebec, which has that limitation together with the limitation or the opportunity regarding a pardon or suspended sentence, Yukon, and again Newfoundland. So there are 5 jurisdictions where a criminal conviction is grounds for discrimination and to be protected under the human rights codes or acts, depending on the jurisdiction. However, having said that, if it relates to employment, as in if an employment-related issue arises as a function of the conviction, then the ground will be set aside. So the most obvious example for that would be, for instance, somebody being looking for a job that involves minors, and a vulnerable sector check would be an appropriate search for a record in that particular context. That just kind of makes sense. There are other examples as well, and sexual assault always rises to the top if it has any connection whatsoever to employability. So there are 5 jurisdictions where that arises. The next one is that there's limited protection if in fact a pardon, what used to be called a pardon and what is now a record suspension, is in place. So Canada as a jurisdiction, Ontario, the Northwest Territories, and Nunavut all provide that particular protection. So that's an interesting kind of protection in that obviously if you have a pardon or record suspension, if you have a conviction, it's not going to be held against you in an employment situation. That particular category doesn't do a lot of good for a lot of people, and it goes back to all the bills promoted primarily by Senator Pate dealing with convictions and the difficulties that are inherent in getting pardons and record suspensions. So that's not a particular avenue that I would look for an amalgamation across the country. And we also have 5 jurisdictions that provide no protection regarding a criminal conviction, whether it's in a code or an act. The only exception is that there's a proviso in Manitoba that if you're applying for a job and a conviction is something that will stand in your way and you're turned down for the job, the Manitoba Human Rights Commission will in fact address that particular issue on an ad hoc basis. All right. Any comments about any of this? Brendan?
It's actually more of a question to make sure I understand properly. So if I'm comparing like the 2 middle categories, limited protection, like let's say for BC, you're saying there's limited protection as prohibited ground relative to employment. But then let's say in Ontario, there's protection if there's a pardon or a record suspension or something like that. Does that mean that, for example, in BC, if somebody has a pardon, there's no protection? Like a pardon does not act as protection in that case?
That's correct.
Really? Wow.
It doesn't define it as a ground of discrimination.
Okay. So theoretically, a pardon or record suspension could mean nothing in BC then?
Well, it could mean nothing unless it has an employment-related issue.
Okay, I see. Okay, I see. Fair enough. Perfect. Thank you.
Anyone else? I'm still working on this. This is all a very preliminary draft. What I propose to do is to do more of an analysis on this. I'll dig a little bit deeper, and then I'll come back to the PRC with a memo on this particular issue and any recommendations I may have with respect to the Uniform Law Conference of Canada coming together in this, which was Howard's suggestion a month or 2 ago, which I thought was an excellent one. So if there are no more comments or questions, then we'll leave it at that, and I'll come back with a memo. Oh, Howard, please.
I keep forgetting about the mute button. I think there's some really tricky issues here for us. One of which is As you recall, our last attempts to do some briefs on the criminal records things indicated a division of opinion in the PRC and at the board. So I think nonetheless there's some, we can choose some grounds or some approaches where there will be a consensus. It may be that prohibiting discrimination is only appropriate where there is a pardon already granted with the time frame. That would, I think, be a minimum that we could agree on. But the other issue as well is I had suggested the Uniform Law Conference as a way to approach doing something on this. And of course, it's only governments that have access to the Uniform Law Conference. So in the end, we would be thinking about writing to the federal attorney general or provincial territorial attorneys general and urging them to take this to the table at the Uniform Law Conference. And I think that's a very appropriate thing, probably writing to our federal minister, because we are more of a federal policy body than anything else, and asking the Attorney General of Canada to take this to that table. It seems to be an obvious area for inconsistency across the country. But the other thing, and this is mostly what I wanted to raise, and maybe get Irving to chime in a little bit on this, I don't see a problem, quite apart from the Uniform Law Conference, with us writing to the provincial AGs directly, either with the assistance of our affiliates if they exist in the particular jurisdiction, or with or without their involvement. The PRC, the CCGA, or us proposing it to the board, that the CCGA writes to the provincial attorney general pointing out this inconsistency in terms of a lack of protection in their jurisdiction, and urging them to get up to speed, we would use more tactful language, with the protections available in some of the other jurisdictions. So I think from a tactical strategic perspective, there is the Uniform Law Conference option, but also the option of writing directly to provincial AGs, provincial territorial AGs. We have done that before, particularly with respect to the study of police use of force, and even with the study that Mark Addo did about discrimination, writing to provincial AGs, sort of indicating all of the reports that have been done and all the recommendations made about taking concrete steps to combat racism and discrimination in our criminal justice system. So, or again, Irving may have some thoughts, but it seems to me there are two paths, both of which I think are legitimate from my perspective. Let me open that up for anyone to jump in or not.
Thanks, Howard. That's great. Irving, do you have anything to say about that?
I don't see any great difficulty. I don't know if we'll have any impact, of course. You recall we didn't exactly get 100% responsivity, I guess, last time with the other issue. I think we could try it. I'm not sure. I think I like to see the affiliates get involved, though, right? Because they know their way around the provinces much better than we do. Perhaps we could. We'll note it in the minutes, Miles, obviously, and I don't mind sending it out, copying the minutes just as an additional piece of information to our various presidents of affiliates, and see what comes back.
All right. Well, that on that basis, then I'm going to make a special note to Peter. When he prepares the minutes, we'll frame this issue so that it's something that could be easily understood, and then run it by Irving and or Howard for distribution to the affiliates.
Yeah. I just have a question, Miles.
Sure.
Pardon me. Nothing precludes an individual who's refused a job, notwithstanding the fact that he or she has a pardon. Nothing precludes them suing based on employment law, right?
Well, yeah, of course. I mean,
complicated. It's it becomes a civil case. Obviously, in most cases, I would imagine it's probably more costly, but notwithstanding.
But having said that, they would, and yes, theoretically, and they could sue based if they were turned down because of a conviction, and they're in a jurisdiction where that's not a prohibited ground. Right. They would be suing them on the basis that the conviction wasn't germane to their employability. But I mean, nobody's going to, in the real terms, nobody's going to do that, and spend that kind of money on something that isn't protected, unless, of course, you're
class action stuff like that.
Let's looking to be the chair of Hydro One, So I mean, unless it's a very high profile position, You're not going to be doing that and even then, because it is a high profile position, the response is going to be, well, why would we want somebody with a criminal record, having this position? Just on very, very broad, moral panic grounds which exist. But anyway, sure, you can sue for anything.
I think of it in terms of stimulating conversations.
Right.
Irving, much more difficult without a human rights provision to rely on, because most employment's under provincial jurisdiction constitutionally. So unless it's a federal undertaking, the question of the Section 15 being arguable in the case is very difficult. So you sue the employer for discriminating, and the employer says, yeah, so what? I'm right to discriminate against you, and there's nothing that prohibits me from doing that in law. So the human rights, the provincial territorial human rights code would give you a leg up in that. Otherwise, you'd have to establish that the discrimination had nothing to do with the bona fides of the employment decision. But a criminal record, an employer can always say, well, a criminal record shows that I can't trust you, or that I'm not saying I like that argument at all, but I can see it being made. The whole point is that having a provincial territorial human rights code prohibition against discrimination gives you an immediate justiciable issue. Right. So I'm not an expert in employment law. I should ask my daughter about this before I keep mouthing off about it. But I think it would be a very difficult suit to maintain where there isn't some prohibition on the particular type of discrimination. But
again, I guess one could go to the Human Rights Tribunal, for example, in Ontario. But as you probably know, they don't make big awards. $10,000 is a lot for them, and they try to settle a lot of stuff. So it's a long process too, I know from experience. So anyway.
Thanks, Evan. Howard.
Okay, thanks.
Hey, Irving. All right, guys. So anyway, I will get something to you in the minutes, and then we'll take it from there and report back next month. Okay.
Miles,
yes.
Thanks for your, thank you for your work on this. I think this is worth pursuing. The unevenness, even at a basic minimum standard of protection of people who've been pardoned from a criminal record is a little bit surprising. So thanks for your work on this. I think it's worth pursuing.
Oh, my pleasure.
In my opinion.
Certainly. All right, guys, bills under consideration. So I want to refer obviously to bills that have had some change since our last meeting. Firstly, in the Commons, Bill C9. It's moved into this, it's gone through the Commons, is in the Senate, it had its first reading on December the 13th. That's an act to amend the Judges Act with respect to it's putting into place basically more of a codification of what's involved in removing a judge from office. All right, and let's see, the next bill that had a change is the Private Members Bill, Bill C-233, which had second reading on December the 14th. That's to amend the criminal code regarding violence against an intimate partner. There are no other changes in the Commons. In the Senate, as was mentioned, I think it was by Brennan earlier and Howard, Bill S4 has royal assent. So that's just posted there. I don't usually keep bills in this list that have assent except for those that have received it since our last meeting. So it received royal assent on December the 15th. That's it for public Senate bills. Private bills, there has been no change, absolutely no change in any private Senate bill since our last meeting. So that's the agenda, folks. Anything else for discussion today? It's a relatively quick meeting. Brennan?
Miles, I would just mention one thing really quickly. So Bill S-205, which is again on its private members Senate bill, is very similar to Bill, I think it's C-233. They're both on intimate partner violence. So both are proceeding through at the same time, and there's a lot of crossover. And it's something that I saw in committee, but for others who might also end up seeing these before their committees, those are also I guess it's just something to look out for, that there's a lot of crossover and they're trying to coordinate them, but there seems to be some pushback against coordinating them. But anyway, two very interrelated bills working on like the same code, sections of the criminal code.
Thanks, Brendan. Yes, S205, there's no change since last month. It's still in committee, from what I can tell. Thank you.
You're right. Yeah.
Thank you. Anything else, folks? Okay, well, like I didn't say this at the beginning, Happy New Year to everybody.
Happy New Year.
Yeah, look forward to a fruitful year for the PRC. If that's it, then I'll see everybody back here on
February 7th, no?
February 14th.
14th, Valentine's Day.
Sorry, 14th.
Yes, we'll all be very romantic at that. On that
Oh, boy. It's all hearts.
yeah,
Don't forget the flowers and chocolates.
you got it.
All right.
Just for you, Urban.
Thank you. So glad, so good.
Just
Glad to hear that.
Well.
There you go.
Yeah, guys. Thank you.